All right, good afternoon. It's time for another round of the Rains Feldman Cyber Liability Roundup. I'm Eric Syverson, of course, and the usual cast of characters is here with Steve Gebelin on my right, Scott Lesowitz, suited and booted today with a tie on my left, and let's talk about an interesting new case that was filed yesterday in Los Angeles. It's a class action. It was filed by a very good attorney and a very famous attorney, Mark Garagos, and his law firm. And Mark Garagos is representing a minor child who has filed a class action against Snapchat, which is obviously a very successful company, I think valued around 14, 15, 16 billion dollars. And so what did this minor sue Snapchat for? Let's start with Scott this time since he's wearing a tie.
Thank you. So they're suing Snapchat because under the law, a website has to, in their terms of use, websites, especially ones that have questionable conduct, have to alert parents of the ability to filter out offensive conduct. So, for instance, they have to give them a link to a service provider that would filter internet content. And here, Snapchat banned users under 13 from using the site at all, but they did not include this provision of telling parents where they could get the filters. So the issue here is the exposure to allegedly obscene material for 13 to 18-year-olds, the 13 to 17-year-olds.
Okay, Steve, what kind of material is at issue in this case? What exactly is it?
So the allegations in this case are based around Snapchat's new edition of a feature called Discover, which is sort of a news sharing service that Snapchat added into its prior messaging platform. So now the users get news links or posts that are news articles created by third parties like BuzzFeed or Gawker or somebody else. And of these, there is a portion that are sexual in nature. So those are the ones that feature prominently in the complaint. I remember one of them was a BuzzFeed article that took screenshots of Disney movies and made comments about the faces being reminiscent of being fucked.
Okay, so it
Yeah.
sounds like PG-13, maybe R-rated, sort of racy humor, but let's be clear, it does not appear that we're talking about something as horrific as child pornography. Is that correct?
Yeah, not pornography and not child pornography and not actual pornography that's going to minors, but sort of the racy R-rated, suggestive material.
Some examples were like tips on inducing orgasms, things of those natures, like kind of like those top 10 lists that are racy that you'd see like in Cosmopolitan magazine.
Right, I was thinking the same thing. So let's play a game of tennis here, and I'll go back to you, Scott. What sort of claims are being alleged? What sort of legal claims are they putting forth?
The under provisions 230, 231 of the CDC, like I said, they're for not using the terms and conditions.
Let me correct you there, CDA, right?
CDA.
Not CDC. And
Sorry.
CDA is something we talk about a lot here, which is Communications Decency Act, and it generally provides websites and internet service providers like a Snapchat with immunity for bad acts of third parties, excluding intellectual property infringement. So get back to your point. So the plaintiffs are saying that Snapchat is not entitled to that immunity. Why?
Well, there's an exception for offensive materials directed to minors, and then also, like I said, the knowingly sent out to minors. And here they were only banning people under 12. So you have this 13 to 17-year-old age range. That's a problem. And also, they said the terms of use for parents. And so one of the questions is going to be, is this material so racy that it would be harmful to a 13 to 17-year-old, as opposed to like a, it'd be a clear case if 6 or 7-year-olds were allowed to use the site. Now, obviously, it's theoretical that people under 13 really can't use the site, but for the law, it's presumed, since it's in their terms and conditions. And so that's to me the gist of the suit.
Steve, what sort of damages are they seeking? What are the damages theories? And I understand it seems like the lead cause of action, if you will, is what, a 17,200 claim, which is in California in plain language an unfair business practices claim. So it's my understanding that that's kind of the lead claim, and is that predicated on Snapchat's failure to comply with the Communications Decency Act, I guess, filtering provision?
Yeah, so the lead claim, their first cause of action is based on California's Business and Profession Code 17200, which prohibits companies from engaging in unfair, unlawful business practices. And you're right, it's predicated on their failure to provide these warnings and their transmission of these suggestive and racy materials to the minors as illegal acts. So it's based on allegedly illegal acts that Snapchat is doing in providing access to these minors access to these articles and getting them sent to the minors. So yeah, that's what the lead claim is based on. They also have a claim for negligence, saying Snapchat is negligent because and you can tell it is because it's violating these laws. The biggest hook seems to be a statutory damages provision in the Section 231 claim that Scott was mentioning earlier. Those have statutory damages of up to $50,000 per instance.
I see, and so, and maybe it's not needed, but usually when I hear an unfair business practices claim, we say here in California that you need to have an actual pecuniary loss, which I fail to see with regard to these minors. But does the fact that the statutory damages award is available, does that count as actual pecuniary loss? Do we know?
I'm not sure.
Does it maybe not matter? Do they have an independent claim aside from the 17,200 where they have access to those statutory damages?
Yeah, they've tried to plead it that way. We'll see how it shakes out. It looks like I would expect there to be motion practice at the outset on a motion to dismiss to see if they've stated claims or if they've stated whether or not they have standing to bring any of these claims. One of the things that might actually come up is another provision of the CDA that we talk about more frequently, the Good Samaritan provisions that prohibit treating Snapchat as the speaker of third-party content. And here, Snapchat's not the one generating any of these articles that are the real problem. They're just providing an internet service where they're being served to their customers.
That's right. And so let's quickly get into the last sort of hot button issue I think we see here is that, and that's the question of whether or not Snapchat can compel arbitration, because as I understand it, their terms of service have an arbitration provision, but I think there's a problem here with regard to minors, right, Scott? Because a minor cannot enter into a binding contract, correct?
Yes, I mean, this is going to be a difficult area. Usually the courts are liberal about enforcing these types of arbitration provisions, especially when there's a click-through agreement. But here, because they're minors, whether they can consent is going to be at issue, and whether they enforce these arbitration provisions or they have to go to stay in court, whether they can stay in court.
All right. Well, that'll do it for this week. It's Friday, and it's almost the cocktail hour, so we'll sign off for this week and see you next time.
And we'll stay away from the Center of Disease Control.
Yeah, no CDC.
That's right. All right.